Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome back Ed Testino, who is sitting to my left, and Dave Greenfield, who is sitting almost directly in front of me. Welcome back to Law on the Line.
Thank you.
And
Thank you.
Anyway, Ed is an attorney in New Jersey. He has a practice in Old Bridge, and he tells me, although he's not a day older than I won't say, that he's been practicing since 1984. And Dave has been an attorney since a little bit earlier than that, and he's the former director of litigation for the New Jersey Waterfront Commission or Port Authority Waterfront Commission?
It was the Waterfront Commission of New York Harbor.
Okay, New York Harbor.
Before it was dissolved.
And the former appellate division researcher. And he's currently actively engaged in mediation, especially in the special civil part. And today what we're going to do is talk about that part of the court, the special civil part of the Superior Court of the State of New Jersey. And what I want to do, and I'm going to start off with you, Ed, and this program is going to be focusing on access to the special civil part, which is really the gateway to the Superior Court courthouse. It's the gateway to the court for litigants. So tell us, what do non-lawyers have to do to gain access to that part of the Superior Court of the State of New Jersey?
Well, this is a limited jurisdiction court, so in small claims we go up to $5,000. In special civil part you can sue up to $20,000 in terms of money judgments. But really, to gain access, I recommend that people go to New Jersey courts online, and most of their questions can be answered there. One time I thought about writing a book, and then I look online and they have all my ideas there. But really, the courts have done a good job in outlining the process, the procedures, and answering most general questions. But basically, we're talking about, in small claims, people suing other people for money. And in special civil part, that money goes up to $20,000.
Small claims is limited to $5,000 now.
Right. But I just want to tell everybody out there, a practice pointer, watch your mail, because you could end up with a judgment against you, because the way they serve people in these levels of the court is through certified and regular mail. I don't know how many times I have people come into the office and we're doing a real estate closing, or they're complaining about they had their credit check, and a judgment is popping up that was secured in one of these divisions. So there are real judgments that are happening, and there's real procedures that occur.
So I decide I want to proceed. I have a claim that I wish to make. I don't have, it's not really large enough to engage counsel. What's the first thing that you recommend a potential litigant to do? Go online, talk about that, where they can find it, and then what do you do? Because there are forms that need to be filled out.
Right, and the forms can be found online, but the first thing I recommend they do is they chart out their outline of their claim so that they can fill in the form. So most people get confused with these forms. You have to understand what you're asking for and what result you want. So that's all spelled out in the forms, but online they have how to file a lawsuit up to $5,000 with a particular form, which we can also put on the screen for the viewers at home on the format to use. Now, the procedures are simplified in small claims. There, I recommend to people, if you get a court date, show up. If you don't show up, you're going to have a judgment against you. And
that's if you're a defendant.
If you're a defendant. You don't get to file answers in small claims. You get to make your defense on the day in court. So that's one big difference from the next level up.
So in that level, the small claims level, the complaint is issued by what we call in Jersey the plaintiff.
Yes.
And what kind of claims are, generally speaking, small claims court handle and the ones that you're most familiar with?
So there's breach of contract, return of money deposits, property damage, bad checks, bad rent, back rent, return of security deposits. You can't sue, and this is for the regular special civil part. You can't sue for malpractice claims. They have special criteria. You can't sue for child support or alimony claims or domestic disputes that has to go to family court. And you can't sue over probate or estate matters. That has to go to Chancery Division as well in the probate or Chancery Division part. But, a lot of people don't understand that the complaint has to be filed. And what does that mean? You have to fill out the form and you have to pay the filing fee. So a lot of people say, I sent it in, but I never got a date. Did you get a check? Did you just pay the money? Did you get proof that you made the payment? Then the clerk will respond to you and tell you whether they're accepting your filing and whether the next step can be taken. The next step is, will they issue a summons? You have to give them the name of the defendant, their address, and why is that all important? There are rules about where the defendant can be sued in this level of court.
What are those rules, very briefly?
Yeah, you have to sue in the county where the defendant resides, or at least one defendant resides if there's more than one defendant.
And is that pertaining to both small claims up to $5,000 and special
Yes.
civil part up to $20,000?
Yes. Yes, so it's unlike the regular Superior Court where you can sue where the plaintiff resides. You have to actually go to the county. So if your contractor that you're suing is outside of your county, you have to go to that county.
Right, you can't. Now you can't file in Middlesex, for example, if he's in Ocean, because the court will reject it. Now, filing is done electronically or in person, because for years we're used to as filing in, by paper. How do people do that today?
That's a very good question, Bob. So, people can create their own online accounts if they are, I'll call them civilians, not attorneys. Attorneys are required to file online, and they have accounts and pay through their, what we call their judicial access accounts. But civilians have to either create the account, pay by credit card, or they can go down to the courthouse, like we used to send them in the olden days, go down to the clerks, fill out the paperwork, and pay your check. Now they have access computers at the courthouse, and they have people answering questions so they can assist you. They can't give you legal advice, but they can assist you with the process.
Is it still electronically filed when an individual goes to the courthouse, or they take paper? Or does that depend upon the county?
If they can't get you to operate the machine, they will scan the paper in, but it's less and less. So they try to get people to put it on the electronic format, because what happens is eventually almost everybody has an email address now. Notices come out on email once the case starts moving. So if you have that information, you're supposed to provide it. If you don't, when the court either gives a date and somebody asks for adjournment, they start gathering the email information. And that's what I was trying to say before. In small claims, if you're going to get an adjournment of a date, you better have it confirmed in writing, because these procedures are hard to get in touch with a judge to give the adjournment. So most of the time I find people really miss the small details about, they have to be in court on time. They have to make sure that if they're not going to be there, that they send notice in writing in advance. So that type of things. So
if a person goes to the courthouse and files a complaint, will the date that person, this small claims court, the date that the matter is scheduled to be heard, that will be sent electronically to that person, or will they get a written certified, used to be a postcard that would spell out the date that you have to appear? The court still sends postcards to individual litigants, and
that's how they get that notice. But once they're on the system, they'll get electronic notices for future dates.
What do you see, Dave? You do a lot of mediation, I know, for the process in, you indicated in Monmouth County, and it's probably very similar all over. What do you see when litigants do come to court? What do you observe in terms of notice that they get?
Well, if it's a lawyer is involved, a formal complaint will be filed with the court and served on the defendant. If it's the people are pro se, that means not represented, the complaint will be written out by hand. But what I would like to say about mediation is mediation, when the parties are in court, they do not see the judge first. They are sent to mediation. And it's the job of a mediator. A mediator is a neutral, and this person tries to get the parties to settle their case. Because we could do in mediation what you can't do in court. If somebody, for example, is sued on a credit card, we could work out a payment plan.
The judge can't do that, is that correct?
No, the judge doesn't do that. Also, the judge has to apply the law and the facts. And the rules of evidence do apply. In mediation, this doesn't occur. Say somebody is sued by a doctor or a dentist, and my question will be, aren't you covered by insurance? And they say, well, I thought I was. At times, I will have that person call the insurance company and find out if the claim was covered, and sometimes it is, and the case just goes away. But we could do things during the mediation session that can never be done in court. I also try to tell the parties, even if you get a judgment, it doesn't mean you can collect it. It's not automatic.
Right, that's correct. But I have a question. You see both sides.
Yes.
Typically, when Ed's in court, he's representing a party, whether it be the plaintiff, person suing, or the person sued. When you see the defendant, the person who's being sued, in that process, that mediation process, do they ever say, look, we only got a notice last minute to appear? That was what I was trying to drive at. How do these folks get notice? Do you know, they say, I never saw the email, or you don't get into any of that?
I probably will not get into that. That might be taken care of during the calendar call.
Okay, and all right, Ed, tell us, so what happens, the calendar call?
Okay, so I just wanted to back up first.
Go ahead.
There's one other proviso in this court jurisdiction. You got to be 18 to sue. You can't be under 18, or you have to have a guardian. We know that as lawyers, but just so the general public knows. So first I wanted to say, how do I prepare for court? Because that'll lead into the day of trial. I mean, the plaintiff has the burden of proof, and we know as lawyers that it has to be by a preponderance of evidence, because we're in the civil division.
More credible than not.
Yeah, yes, and they got to prove their case. So they got to outline their evidence, whether it's going to be arranging for witnesses, because you can't bring a certification in or an affidavit and say, Judge, I want to introduce this, because that's hearsay, and most people have heard hearsay, but it's an out-of-court statement that's used to try to prove something, because there's no availability of cross-examination of that document. You got to organize your documents. It's one thing, I think, mediation, you come in, people are throwing papers around, they're unorganized. So part of the thing that Dave or any other mediator is helping the court do is get the parties organized to understand where their case is or where it's not, because they don't do it before they come in.
If I could just interject,
Sure.
Ed is correct about that. Some people are organized, and even before mediation, let me see the bills, let me see paid bills, let me see photographs if somebody's complaining about property damage, or if somebody's complaining about a contractor doing a bad job. Let me see the photographs. When were the photographs taken, by whom, and come in with real evidence.
Come in organized, and that evidence correlate with the counts of the complaint, if it's more than
that
one
counts
count.
just for mediation, just as and even more so if the case goes to trial.
Of course.
Yeah, so I want to say, make an original in 3 of the copies, You got one for the mediator, you're going to need one for the adversary, because the judge is going to tell you to exchange discovery and mediation, because he's not going to want to hear you say in the trial, oh, here's another document, and he's going to say, did you show your adversary? And if you didn't, he's going to make you step outside and go to the back of the line while he takes on other cases, because you got 50 to 100 cases in there being heard on that particular day.
And that's pretty typical.
Yes. And then the other thing I want to say about, Dave mentioned photographs. You can't hand your phone up to the court. They're not going to accept it. So you got to print out the photographs off of your phone and, again, make copies for the other side in the court and the mediator. And also, if you have videos, that's another difficult area of presentation, because how are you going to play it? You need to either check with this court staff on how to play it, or you're going to have to bring your laptop in and be able to play it for the court, because you're not going to be allowed to stick a hard drive into the court's computer system. It's just prohibited. So
can you bring your phone in to show a video that may be on your phone?
Judge Corson in Middlesex will not touch your phone. He doesn't allow it.
Period.
Period.
Even if you can manipulate the photograph.
Even if you can, he doesn't want to touch the phone because there's a lot of private data on there. He has to make a court record. Everything that's being done in the courtroom is being recorded. There's a court smart system, and the evidence has to be stamped in. Sometimes it's held by the court for an appeal purposes or other rulings, and he's not going to keep that as in the evidence log.
And just another interjection, in mediation, I've seen videos on a phone, but this is a lot less formal than the actual proceeding before the judge.
So I'm going to get back to you in a second on that. Ed, in the process, the litigation process, you was talking about that. You're the plaintiff, you have your complaint filed, you have to be organized, it has to be specific. Plaintiff has to go first in testimony. Is there cross-examination allowed in both special civil part, small claims, and the actual special civil part?
Oh, yes, that's a key component of the trial. They have to be in the format of questions. Most people start testifying on their own side of the case when cross-examination is really to probe the veracity or the limits of the statements that were made or evidence that was introduced by the other side.
Is there any recommendation you can make or advice about how does one phrase an appropriate question on cross-examination?
Well, basically it's where, what, when, how, or why. If you're not asking one of those questions, and then it's not a question, basically. And most of the time, you want your question not to be compound, so the simpler the better is my advice to anybody that's watching.
And so the bottom line is just don't think that you could just go on and testify, because that is not appropriate, and the judge will stop you, even though the plaintiff may not. Am I correct on that?
You're correct. And Dave mentioned it, but I just want to point out that a lot of people come to court and they don't have some basic pieces of evidence. Canceled checks, monies, orders, receipts, the contract, the bills, estimates, leases. These should all be in your folder, ready to hand up to the mediator or to the judge so that they can understand what the four corners of the agreement were. If it was in writing, you have a better chance of proving it. Not that you couldn't prove an oral agreement, but most of the time, the court wants to see what the party's understanding was, and they don't want to have to interpret it, the judge that is, or the finder of fact, whoever's trying to settle it. They want to have to interpret it or imply what the terms of the contract are.
Well, even in mediation, I'll ask a question. Where is this? Where is that? Oh, I have it at home. I said, at home is not good. You're going to have to get it here. If this goes to trial, you're going to have to get it here. And then, can I have an adjournment? I can't give you an adjournment. You got to ask the judge.
So the question I had in that regard is, when in the process does the mediation happen chronologically in the order of
the day of court, right?
Yes.
Yeah,
day of court. You come in, you check in. Usually in Middlesex, They have everybody in the room, only one person from each side, and they do a roll call. This is usually done by the clerk and one of the assistants for the staff. They call out the name. You should have your docket number ready. You should say ready defendant or ready plaintiff. If you have a problem, you say problem, and then the court will address it after the roll call. Then if there's two ready sides, and defendant shows up, plaintiff shows up, that's what they call a match. They'll put it in a pile and start sending it out to the mediator. It's mandatory to go to the mediation. If you haven't gone to mediation, you're not going to get in the trial queue. You might not want to talk to the other side, but that's why the mediator is there. He or she will ask the questions, keep the parties civil, and decide and make recommendations. You don't have to settle. As Dave can tell you, you could try to get your case tried. You may sit and wait the whole day or come back the next day. But the end of the day is people usually aren't too happy when the judge makes a ruling. Sometimes they don't have their evidence. Sometimes they don't prove their case, or sometimes the defense proves their defense or their case.
Now, in small claims court, there is no answer that is filed. In other words,
Right.
I sue somebody for $500. His claim is I don't owe it. In fact, I don't owe him the money. I did the work. Is there an ability to counterclaim if you're a defendant?
Very limited. If you're going to file a counterclaim, you're going to be kicked up to special civil part because it's more complex.
So automatically, is that correct? It's automatic?
Well, you're going to pay an additional fee, and it will go on the special civil part calendar.
As an answer and counterclaim in the
Right.
special civil part. So if I say, well, he's suing me for $500, and in fact, I did the work, and I'm going to counterclaim for him because I did extra work, $750 I am owed. That would have to be then moved up to the special civil part. Is that correct?
That's my understanding of the rules and how it works, and they just don't have the mechanism set up to handle complaint, answer, counterclaim. That mechanism set up for the next level.
Okay, David, special civil part, small claims, and I'm now mediating because, I've never been to court before. I'm suing him for $500, and I say, look, I did $750 of work. He's only paid me $350. He wants $500. I want $450 from him. Why do you handle that in mediation? You tell them that they can't do that, or what?
Well, I don't do small claims mediation.
Okay.
But if I did, I would say, look, we're in mediation now. Let's see if we could work this out.
The whole thing.
Yeah. And,
You get both sides at that point.
right.
You can't do that, though, in small claims if you're representing one party and the other party.
I usually don't go to small claims
Okay,
either
I
because
know
people
that.
can't afford. This is a relatively lower limit so that people can
$5,000. Do it on their
settle
own.
smaller claims. But I just wanted to finish
Go ahead.
the day of court. If you don't settle and you have a trial, there could be a judgment. It's a written order of the court that gives you a money award. That's not the end of the case. We'll get a little bit into that if we have time about how to execute on the judgment. But you can appeal from that judgment. You have 45 days. It's a complex procedure. You have to pay a fee. You have to get a transcript, all that.
So,
But I was going to cover more of that when we go over.
well, let's do that. So, Ed, really, what at the trial level is you give your best shot with the proofs that you have at hand, and if in small claims court, try to convince the judge that you're owed what you claim you're owed. The distinction in special civil part, where the $20,000 jurisdictional limit is what when you're a defendant?
Yeah, so there's more court rules involved. There's more procedures involved. There's an answer filed. The defendant gets served the summons and complaint. I didn't define that before, but summons just a written notice of that they're being sued, and that process is started. Then they have 35 days to answer. They have to pay a filing fee to file the answer. There's also forms online that show you how to prepare the answer. And again, you can go to the clerk's office and do this if you need
And if you
assistance.
have a claim against the plaintiff, that would be an answer and counterclaim. Is that correct?
Yes. So here, the rules apply with regard to what we call joinder of claims. So if you have a related case, it has to be brought at the same time. So if there's a contract, you claim he didn't pay you, the other side claims you damaged their property, it all has to be brought at the same time in the same setting.
The entire controversy document.
Yes,
Correct.
exactly. I didn't want to use the
That's okay.
the terms that we do in
Yeah, we use
the
those terms
practice
and
of
people-
law, but that's
what it's
how
called.
what we refer to. And there are plenty of people that self-represent in this level, even though you see a lot more attorneys involved when the number starts creeping up over $10,000, because let's face it, it's a lot of money, right?
So let's get to the point where, Dave, the mediation has been successful. Very briefly, because I only have a couple of moments left. You prepare a document.
Yes, we do. We prepare a stipulation. Usually on very complex cases that I get assigned to by an upper court, I let the parties, we just do a term sheet. Here, especially where the parties are unrepresented, I'll write it out. I show it on a special form. I show it to both sides. Do you understand it? Did anybody force you to into this agreement? No, it's fine.
Do they have to sign the
They have
stipulation
to
at
sign
that
it,
point?
and I co-sign it as mediator.
And then you get it to the judge, ultimately?
What I do is I give it to the clerk.
And that's it. We have a minute left.
Oh,
Collecting
so-
a judgment.
Well,
Ed, and let's
I just-
wrap it up.
Let me give it a little bit more than that.
Okay, go
You
ahead.
got in special civil part over $5,000 up to $20,000. We have written discovery that applies. That could be interrogatories or document demands. There could be motions, summary judgment motions, and failure to provide discovery motions, which could strike your complaint or dismiss your defense. There's defenses of, that can be asserted. There's motion practice, in other words. Collecting the judgment is the other half of the whole case. As far as I'm concerned, the first half is getting the judgment. The second half is collecting it, because why? You got to find the money. People could file a bankruptcy or they could appeal. But really, there's different ways. There's a writ of execution, a wage garnishment. There could be a bank levy, a seizure of a motor vehicle. They could put a lien against real estate. And my favorite way is docketing the judgment with the Superior Court, all of which there are forms on New Jersey courts
Okay.
online
So-
that you can access to do these things.
I just got the signal that we have to wrap it up. But I would like to invite you guys back now to talk about collecting judgments, because I think you said that's half. We only gave
Yeah.
that about 3 minutes.
Yeah,
at
there's
most.
post-judgment discovery too.
Okay.
The information subpoenas, and there's objections to all this.
Okay, we have to wrap it up. And, I learned how to appear in special civil part, and I appreciate it, gentlemen. And thank you, Ed, thank you.
Thank you, Bob. Thank you for having us.
Oh, it's a pleasure.